Assalamualaikum warahmatullahi wabarakatuh. Welcome back. So this is part 3 for the Zoom recorded lecture for the topic contents of the contract. So in this part, we are going to look at condition, okay, warranty, and intermediate or innominate terms. So all are classified under terms basically. Yeah. Okay, to start with, for the statutory definition of the words here, for the statutory definition of the word condition, warranty, it is contained in section 12 and section 13 of Sale of Goods Act 1957. So other than Contracts Act 1950, we are going to refer or cross-refer to Sale of Goods Act 1957. But again, Sale of Goods Act is only limited to transaction involving sale of goods. Okay, what is so when we talk about when we talk about express term here, so in the earlier part, okay, we were discussing about whether the statement is representation or whether it is a term. So what's the next step here? So once it is decided that a statement is a term, okay, rather than merely a pre-contractual representation, or even maybe it's just a mere puff or exaggeration. Now, the important action is to decide, okay, which type of term is it. I mean here, from the word term here, it might be, I mean, it can be classified, okay, into, it can be categorized into 3 for the categories or types here. Okay, in order, so we need to know whether is it a condition, or is it a warranty, or is it innominate or intermediate terms. Because why? We need to identify, or we need to figure it out, because different remedies are available for different categories of terms here. So that we have three classes or 3 types here. It's either condition, or it's either warranty, cannot be both, okay? Or maybe it is in between. We call it as intermediate or innominate term. Let's have a look at it one by one. Okay, conditions. Okay, what are conditions here? Okay, conditions is plural. Okay, if only one condition, then it is a noun. So sorry, it is a plural or singular plural. Okay, so condition with S is plural. If only one condition, then it is a singular. Okay, single. So a condition is a fundamental, the basis of it. Okay, fundamental part of the agreement. So in other words, condition is something which goes to the root of the contract. Without it, then there's no contract at all. So in other way of describing the word here is that a condition is an essential term of the contract. Very, very important, very the essence of it. So the failure to perform, okay, of condition here, it entitles the other party, the affected party, the victim, to treat the contract as an end. I mean, the contract ends there. Okay? Without this condition, the contract cannot proceed. It ends there. It is considered as being rescinded or terminated. So if the statement of facts prove untrue, okay, or the promise is not fulfilled later, so the innocent party, the affected party, may treat the breach as a repudiation, which discharge him from further performance of the contract. I mean, here the other party who is being affected, I mean, he is being discharged from further obligation, no need to perform the contract, because the other party has breached the contract by not performing the terms here. And on the part of the affected party here, the we call it innocent party, he can also claim for damages. So there are 2 remedies available to him. Okay, asking for monetary compensation damages, as well as it discharge, okay, the party from further performance of the contract. Okay, and this is the illustration. Okay, so breach of condition, it give the injured party the right, okay, the legal right here, either. So first, he can just proceed with the contract, go through with the agreement. But if he choose to proceed with the contract, he can still apply or ask for monetary compensation damages. Or another choice, another alternative is that he can terminate the contract with a stop and the contract. And then he can refuse to perform his part. No need to perform his part, just terminate the contract. Okay, so here there are two available remedies. Can terminate, can go through, can ask for compensation. Okay, the case is Burn and Burners, in 1862, common law. yeah, this is the quotation, okay, part of the judgment here. It was agreed by, sorry, this is part of the facts here. It was agreed by the charter party. So in of charter party, in this case, that the ship, so to charter a ship lah, to sail from one port to another port, from one location to another. And this is the actual wording in the agreement, okay, charter party agreement here. In the port of Amsterdam, okay, show with all possible dispatch, proceed to Newport in Monmouthshire, okay, and there taking cargo. So that's the terms, okay, in the charter party. And then actually when they sign the contract, okay, when both of the parties sign the contract, executed the contract, at the date of the contract, the ship was not at Amsterdam yet, but actually the ship was at another place, a distance away, 62 miles distant from there, from the place where they signed the contract. And then being detained by contrary winds. So the ship cannot sail to the place of the contract, execution of the contract. She did not, okay, she refers to the ship. She did not reach Amsterdam until later, 23rd October. So the moment the ship reached Amsterdam, so she discharged her cargo, okay, as speedily as possible because it was delayed, late already. And the ship proceeded direct to Newport, okay, as agreed in the agreement. But where she arrived on the 1st December, it's too late already, okay, here. So because of that, the defendant refused to load her, didn't want to proceed with the contract, didn't want to use the service of the ship. Now, plaintiff sued for damages, and defendant pleaded that the ship was not at Amsterdam, okay, at the time of the making of the contract. When they signed, okay, the ship was supposed to be at Amsterdam, but the ship was not there. That's why it caused the delay whatsoever here, okay. And the court held that the fact that the ship was not in the port at the date of the contract, so it discharged the charterer from further performance of the contract. There's a breach here, okay. And the statement was a condition because of the commercial importance, okay, that charterers attached to such descriptive statements, okay. So the court referred to this part of the contract, okay, here in the port of Amsterdam. So it was very important that the ship need to be there, okay, when they sign the contract. Okay, that's why for the purpose that the ship can just proceed to the new port. But real fact it was that the ship was not there. It was a distance away. So that's why there's a breach of the condition. Okay, it's very important that the ship was at the port, okay, at the Amsterdam. We have local case report. This is very important because what decision by federal court. The case name is Tam Chio To and Associated Metal Smelters, 1972 case. It involves sale and purchase of certain melting furnace to melt certain aluminium or alloy whatsoever here. So this is the observation where there is a breach of condition which entitles the plaintiff to waive the contract. So in that particular situation, he may instead elect to treat the breach as a breach of warranty because warranty is the lesser degree compared to condition, okay, lesser level. You have the right to treat the breach of condition as a breach of warranty. Breach of warranty, it gives you limited remedy compared to breach of condition. What happened here? This is a case, obviously. So respondent wrote to the appellant to order 1 unit lead melting furnace as per specification, and there was delivery of the furnace. But later, respondent discovered that it was the furnace was unable to reach the temperature. It must reach certain temperature in order to operate. To be operative, to perform the specific function. Okay. So because of that, respondent sued the appellant for damages suffered as a result of the furnace never reaching the temperature required for lead smelting for which it was purchased. So the issue in the federal court was that, whether the ability of the furnace to reach this specific temperature, 2,600 Fahrenheit, was a term of the contract. So federal court upheld decision of trial court because the answer was in affirmative. Yes, it was the condition, actually, of the contract. And the court held that yes, there was a breach of express condition So respondent was entitled to waive it, and respondent can say, oh, it's just breach of warranty rather than breach of condition. Again, the court cross refer to section 13, section 1 of the Sale of Goods Malay States Ordinance 1957. Okay, let's compare with warranty. Okay, just now condition, now warranty. Warranty is lesser degree compared to condition. Condition is the higher one. So warranty is a less important term, still a term, but lesser importance compared to condition. And then it may be part of a contract or it may be collateral to it. So in other words, warranty is a subsidiary obligation, okay, which is not really the essence of it, not vital to the overall agreement. But again, it is also part of the term, but it's just lesser important. So in relation to which failure to perform, it does not totally destroy the whole purpose of the contract. And here, the party can still proceed with the contract. It doesn't affect the whole thing. It doesn't go to the root of the contract, but it is part of the contract as well. So breach of warranty does not give the right to terminate the agreement. In here, the affected party cannot set aside, cannot put an end to the contract. But here, in this particular situation, the injured party need to proceed with the contract, complete their part of the agreement, but he can sue for monetary compensation, can sue for damages. So that's the difference between condition and warranty. Both are part of the contract, terms of the contract, but it is lesser important if it involves warranty and only one remedy. You need to proceed and then can sue damages later. But if there is a breach of condition, the party can treat as breach of warranty. They no need to put an end, just proceed and then can ask for damages. So this is the case, the common law case. Bettini and Guy reported in year 1876. So what's Bettini? Bettini, he was an opera singer. So he was engaged by Guy, okay, to appear in seasons of concerts, series of concert here. And then he promised, he undertook to be in London at least 6 days before the first concert because he need to do the training and rehearsals. But he arrived 3 days late instead of 6 days. Then he arrived 3 days late, so 3 days before the concert. Because why? He was not well, okay, temporary illness, and he didn't inform a Guy here, okay. He gave no advance notice, and Guy, because of that, Guy refused to accept his service. No contract whatsoever. The deal is off. Okay, that's why Guy insisted on. Okay, I mean here, no, we cannot proceed with the contract because why you arrived late. What was the decision by the court here? The court held that the plaintiff had been engaged to perform for a 15-week season, not 1 week, 15-week season, series of concert here. So failure to attend rehearsal, not failure to perform. Failure to attend rehearsals could only affect a small part of this period. It doesn't affect 15-week period, 15-week season here actually. So the promise to appear for rehearsal was a less important term of the contract. Okay, and because of that, the court held that defendant could only claim for compensation, and it is considered as breach of warranty. But defendant cannot repudiate, okay, cannot terminate, cannot put an end to Bettini's contract. It would be different, okay, if we twist the facts a little bit. For example, if he failed to perform for the first week, for example, so it affects the whole concert. I mean, it affects the full performance here of the 15-week season. Here, he just failed. He was being late for rehearsal. So part of the contract, but it's just a mere warranty rather than condition. So the case is very important because why? It describes clearly, okay, the difference between condition, warranty, and the effects, the remedy, okay, entitlement of the remedy towards the affected party. Okay, for the purpose of a better comprehension or understanding, not sure whether this case is in your textbook or not, but you can always read from Nexus Online. The case we have the case like Tan Chong and Sons Motor Company Sdn Bhd and Alan McKnight, okay, in year 1983. We also have the case of Ching Yik Development and Setapak Heights Development Sdn Bhd 1996, and some other cases as well. Okay, the third category, we have we have discussed the first two, condition, warranty. We have the third category which appeared, okay, later. Okay, it is known as intermediate or innominate term, because before before this term was invented or emerged here, okay, for for some time, it was thought that these were the only two types of term possible. In here, whenever it involves term, it's either condition or warranty. But later, this simple classification has been rejected by the court because they are being too restrictive. In here, we need third category. So a third type of term has emerged, and it is known as innominate or intermediate. So what's the meaning here? Because why? Certain or some contractual undertakings, they are so complex, so we cannot really classify, is it condition, is it warranty? I mean, it's not possible to determine from the very beginning. Okay, because in some cases, it is impossible to classify in advance, okay, whether is it condition or is it a warranty. Okay, so what the court can do is that the court will assess in the lights or by referring to nature and foreseeable consequences of a breach. So the court will look at the consequences. Then only we can tell, oh, this is term, or this is condition, or this is warranty. But when they sign, we cannot tell, is it condition, is it warranty? So we need to know what's the real consequence whenever it happens later. So if a breach of the term results in severe loss, okay, and damage, so the injured party will be entitled to repudiate the contract. But whenever the breach involves minor loss, okay, so the injured party remedies will be restricted to damages only, cannot set aside, cannot end, okay, cannot put an end to the contract, cannot repudiate the contract. So we have the case of common law. Hong Kong Fur Shipping Company and Kawasaki Kaizen or Kaizen Kaisha, 1962. So this is the case in which the court created, important because why? The court created a third class of contractual term, okay, outside of warranties and conditions. So it was known as innominate term. So how do we determine it? Okay, determined by the consequences of the breach of the contract. And this case is important because why? Significant because it represented a significant change in the standard of determining types of term. Because usually we look at the contract, the terms here, when the contract was being signed or executed. But for this third category, we look at it after the breach happened. Okay, we look at the consequence of the breach. Meaning if there's a breach, then only we can determine. If there's no breach, then there's no need to determine whether it's condition or warranty. Okay, let's have a look at the brief facts here. So Hong Kong Fur, the company, it contracted with Kawasaki, okay, for what purpose? To charter a vessel for a period of 24 months. And a provision in the terms warranted that the vessel was fitted, meaning there was assurance in the contract, fitted in every way for ordinary cargo service. So fit for the purpose, basically. But soon after the ship, soon after beginning the voyage, okay, it was discovered that the vessel was in need of many repairs. Okay, not really fit, actually need all the repairs here. And then Hong Kong Fur spent 5 weeks, okay, fixing the vessel. But the more you repair, the more you discover. So more damage was found, and so more repairs were needed. So it in total 15 weeks were needed, okay, instead of 5 weeks. Before it can start the voyage before it was seaworthy, were to sail. Okay, so again, the contract was for 24 months, and here the period of repair was 15 weeks, which is how many months here? For almost 4 months, all right, out of 24 months. So Hong Kong Fur repudiated the contract on the grounds that a condition of the contract was that the vessel was seaworthy. But Kawasaki now sued Hong Kong Fur for damages from the repudiation of the contract. Here Kawasaki counterclaim. Okay, I'm asking for damages because you repudiate the contract. Hong Kong Fur repudiated the contract because why? The vessel should be seaworthy, but it wasn't seaworthy because it needed repairs. Okay. So the court held that now what's the real issue here? The court need to determine, need to ascertain the meaning of seaworthiness here. Okay, whether is it a condition or is it a warranty? So the meaning of the term seaworthiness here has a very broad meaning. It ranges from trivial defects, just little defects here, like missing life preserver, or a major flaw, okay, major defects that would sink the ship. Alright. So accordingly, it is impossible to determine ahead of time what type of term it is. Okay, seaworthiness here. Is it condition? Is it warranty? So thus the type of breach must be determined on the consequences. Okay, it depends on the nature of the repair. Okay, the defects here. Okay, the extent of the defect, how extensive the defects were. Okay, and the court said that, okay, rather than seeking to classify the term itself as condition or warranty, so the court will look at the effects of the breach, okay, and then the court came to the conclusion 20 weeks, okay, so total is 20 weeks actually, okay, out of 2-year contract, 24 months, okay, period, did not substantially deprive the defendants of a whole benefit. Because why? The ship can still sail later, seaworthy later. Therefore, they were not entitled to repudiate the contract, cannot put an end to the contract, but can ask for monetary compensation. Okay, we stop here. So we are done with the discussion on condition, warranty, and innominate term. So we are going to continue later. Let's stop share. Okay, Assalamualaikum warahmatullahi wabarakatuh.